I'd like to welcome everyone to tonight's hearing and briefly introduce our panel. On my far right, we have Justice Hackland from the Regional Senior Judge, the Superior Court of Justice in Ottawa. In the center, Justice Louise Saron from the Supreme Court of Canada. And closest to me is Justice Robert Smith, again from the Superior Court of Justice. Now, before we begin the hearing tonight, we are actually going to pose a few photographs. So we have a few seconds to go, and I'd ask Bernie to come forward. And if you're in a real court hearing, don't do this. Who's the first felon counsel? And could you all go behind and just get a picture
You should also not do that in a real court.
with permission of the court. Thanks, Bernie. So just as was the case on Saturday, each student has about 15 minutes, and I'll be sort of keeping time if people tend to go a little on. And so at this point, I guess we can begin.
Case of Pacific Promotions Limited versus Derek Blair Donaldson. Are we ready to proceed? Invite the appellants, please.
Good evening, Justice Saron, Justice Hackland, and Justice Smith. My name is Dennis Myers, and I represent the appellants in this case, along with my colleague, Mr. David Turner. The appellants are seeking an order from this court varying the judgment of the Court of Appeal of British Columbia and imposing a duty of care on commercial hosts. I will be speaking for 14 minutes about whether the relationship between the appellants and the respondents falls into an existing category where a duty of care exists. I will then be speaking about foreseeability as it pertains to the first branch of the ANS test. My co-counsel will then continue on with the ANS test and speak for 14 minutes about proximity as it pertains to establishing a prima facie duty of care. He will then discuss policy considerations that suggest that a duty of care should not be imposed on the appellants in this case. We would also wish to reserve 2 minutes for a rebuttal. At the present time, I would like to offer to briefly summarize the facts of the case if the court wishes me to do so.
We're very familiar with the facts, but if there are some facts you want to highlight as part of your argument, free to do so.
I think that we're okay with the consent point. The appellants assert that the current relationship between the appellants and the respondents does not fall into an existing category where a duty of care already exists. As defined by Justice McLaughlin in Childs versus Desarmont, quote, the reference to categories simply captures the basic notion of precedent, where a case is like another case where a duty of care has been recognized, one may usually infer that sufficient proximity is present, and that if risk of injury was foreseeable, a prima facie duty of care will arise, end quote. Now the current categories that exist now that are most closely related to the present case were established first in Manow versus Jordan, Jordan House, where the court established that alcohol-serving establishments owe a duty of care to intoxicated patrons who leave their bar. The court also established in Stewart versus Petty that alcohol-serving establishments owe third-party users of the highway who may be harmed by intoxicated patrons who are driving.
Well, on the Stewart point that you make, and paragraph 13 is a convenient, of your factum is a convenient excerpt. Justice Major, as you say, does indeed say that such duty is owed to third parties who may be using the highways, but is the first part of what he says not somewhat wider? He says it's a logical step to move from finding a duty of care is owed to patrons to find that a duty is also owed to third parties who might reasonably be expected to come into contact with the patron. Is it not a bit wider than simply the highway users that are one example?
The appellants assert that this is not the case, that there's a significant difference between users of the highway who will come into contact with intoxicated patrons who are driving versus a patron such as in this case where the intoxicated patron is walking. And so the appeal judge stated that there are existing, that Stewart and Petty, the example of Stewart and Petty fits into the broader category of commercial hosts who subject third parties to risk. However, the appeal judge erred in including the appellants into that category because, as Justice McLaughlin says in Child, the governing philosophy behind this broad category of commercial hosts is the element of risk. And that element of risk is lacking where an intoxicated patron is walking as compared to when an intoxicated patron is driving.
Would there not be a risk even inside the hotel, for example, if patrons are allowed to get intoxicated, that they may really seriously injure another patron by getting into a fight?
Very, very much so. There is, of course, risks associated with serving alcohol to patrons, and there are many risks. However, at this stage, the appellants assert that the issue is whether it is analogous to the present cases. So in the current situation, the incident occurred outside of the bar. It did not occur inside. And this is a key distinguishing factor when looking at whether the current case fits into an existing category. Furthermore, Mr. Briggs testified at trial that he had consumed alcohol, but as the trial judge stated, and the appeal judge confirmed, quote, "There is no evidence that the alleged inebriation among the crowd on the mall contributed in any way to the incident in question. Moreover, there is a dearth of evidence that the inebriation of either Mr. Donaldson or his assailant was a factor," end quote. So in addition to the fact that Mr. Briggs was footbound and was not driving a motor vehicle, there's also no evidence to suggest that intoxication was a factor. Both Stewart and in Manow versus Jordan House, this was a key factor in those decisions and the establishment of those duties of care. The appellants assert that this is an important case. I think that is evident to everybody, that has wide-ranging repercussions on society. We're talking about establishing a duty of care for alcohol-serving establishments to all third parties who may be injured by intoxicated patrons who leave their establishment. For this reason, the appellants feel that it is necessary to proceed, at the very least, with the ANS test. Stewart versus Petty. The ANS test was summarized by the Supreme Court in Cooper versus Hobart. The first branch of the ANS test requires establishing that the harm to the plaintiff was foreseeable and that there is sufficient proximity between the plaintiff and the defendant to warrant establishing a prima facie duty of care. The second branch of the ANS test allows for the contemplation of residual policy considerations that should negativize the establishment